Starting out with a law degree can feel a bit like taking up a new language. There are so many phrases and expressions that unless you're really familiar with them, they just seem to be incomprehensible.
This video series is intended to help you with that. In part 1, we'll be looking at terminology associated with the legal system.
Judgment, be careful how you spell this. It's kind of a running joke in, just law that people misspell judgment. Is very funny. Judgment is the decision of a court on a particular matter. There may be one judgment involved in the overall decision, or there may be several different judgments given by different judges in the court, depending on the court that is delivering the judgment. There may also be dissenting judgments in a court decision. These don't have any binding power against the parties, but they do represent the views of judges in the minority in a particular case, and they may be used as sort of like persuasive authority. So if you're writing an essay about something, you could include the dissenting view of a particular judge in order to argue for a particular thing. When you read cases, or case summaries more specifically, such as those provided by lawprof, please check out the link in the description, you'll often see the phrase, "the court held that ... And what that means is basically just what the court said in relation to a particular case. Okay, ratio decidendi. We're on to the Latin stuff now. Yeah, the ratio decidendi, or ratio for short, it's the legal principle that is created by a particular court decision, which is binding on lower courts. So for example, just using a case to illustrate this, in Jackson versus the Attorney General, the court was asked to assess whether the Parliament Act 1949 was primary legislation and whether the Hunting Act 2004 was valid. We don't really need to know what things like primary legislation mean at the moment. In this case, ultimately, the House of Lords held that the 1949 Act was primary legislation and that the Hunting Act 2004 was valid. The decisions as to these questions and the reasoning behind these decisions can be described as the ratio of the case, because they sort of correlate to the actual question that was asked before the court. By contrast, obiter dicta is a part of a court judgment that does not actually correspond to the question or questions raised in the case before the court. So obiter dicta aren't actually binding on lower courts, but they may serve as persuasive authority in later cases. Going back to the Jackson and Attorney General example, some of the judges made remarks about parliamentary sovereignty in this case, and they suggested, rather controversially, that it was not an absolute principle of English law, as it's usually understood to be. So you'll learn all about this in public law. But anyway, these remarks can only be seen as obiter, because the question of whether parliamentary sovereignty was an absolute rule or not wasn't actually asked in the case. The doctrine of precedent is the principle that courts should follow the legal precedents established by higher courts when dealing with cases with similar facts to the cases where those legal precedents were established. So for example, if in a particular case the Supreme Court decided that a man had broken the law because he had driven his car too fast and based this decision on the principle that you should not drive above the speed limit, lower courts would be expected to apply this rule without being able to overturn it. It would apply not just to cars but to all road vehicles, because the reasoning of the Supreme Court in the case with the car driving too fast was that you can't drive any vehicle above the speed limit. It's not just cars. So yeah, case law is the law as established by former decisions of courts. Because of the principle of doctrine of precedent, the outcomes of previous cases can serve as legal rules in themselves under a common law legal system. Okay, doctrine. It's quite a hard thing to define, but what it is really is an established rule or set of rules that operate within the law. And that doesn't really tell you anything, really. Maybe we can sort of look at an example to explain this. An example of a doctrine is the doctrine of stare decisis, or the doctrine of precedent, as we explored earlier. So it's the principle that lower courts should follow the precedents set by higher courts. And generally, doctrines tend to be very important rules or sets of rules in a legal system. These rules are the ones that sort of get the label of doctrine. And going back to the doctrine of precedent, it's an extremely important part of the English legal system, since it basically means that previous courts' decisions serve as laws in themselves to be followed and applied by subsequent courts. So it's essentially what underpins the common law legal system. Okay, policy. You'll hear this quite a lot in sort of case analysis, case judgments and things like that. It's quite a broad term in this sort of legal sense, but essentially it refers to the reasons why particular laws are created or why particular court decisions are made. So for example, one of the policies behind the doctrine of consideration, which is the idea that in a contract there needs to be something for something. One of the policies behind that is to stop someone from being taken advantage of in a contract. So for example, they might promise to give away a large sum of money on a whim. They wouldn't actually get anything returned from that if it were held to be a valid contract. So the doctrine of consideration steps in based on the policy that that person should not be taken advantage of. So in law, it's often said that judges may make particular decisions due to policy motivations rather than principled reasons. And this is particularly true in cases involving some kind of public entity, such as a local authority, a police service, or health staff. Courts often apply different rules to them than they would in equivalent cases involving private entities or private people. This is done in order to limit the instances where they could be held liable. The policy reasons behind this include A, to stop bodies that are funded by taxpayer money from having to pay out loads of money in legal costs and compensation, and B, to prevent people from being dissuaded to work in particular public services due to the threat of legal action. This is particularly true in cases involving medical professionals. Okay, hopefully this video has given you a better idea of what all of this confusing terminology means. If it has, remember to give the video a thumbs up. At the very least, I hope this hasn't left you more confused as to what all of the terms mean. But to be honest, with a lot of the terms, you just come to learn them by osmosis as you go through the course of your degree. For example, the concept of stare decisis is hard to define, but once you start studying it, you just kind of get an intuitive understanding of what it actually means and how it works in practice. So don't panic if you haven't got the grasp of all of this terminology yet, you'll get there. Okay, so if you haven't already, please remember to subscribe, and if you have any questions about any of these terms or any terms that we haven't discussed here, please leave them in the comments below and we'll get back to you.